Aragaki. I am the director of the Center for Negotiation and Dispute Resolution here at UC Law SF. So today we welcome Nancy Welsh, who is the Frank W. Elliott Jr. University Professor and Director of the Aggie Dispute Resolution Program at Texas A&M School of Law. Nancy really needs no introduction to an audience like this. She's really one of the leading voices in ADR scholarship today and has had a long-standing interest in issues, especially relating to court annex mediation and issues of procedural justice, both of which are topics she will thematize in her talk. So we're really honored and delighted to be able to welcome you here today, Nancy, to share your new project, which is entitled Could Lawyers' Court Annexed Negotiations Represent the New Mediation, which is also a project, I should say, that you are engaged in with Donna Shastowski, who is a law professor at UC Davis and also a longtime friend of CNDR. So before I introduce your talk, I'm going to cede the floor to Daniel Rivera of the Mediation Society, which is the organization that is co-sponsoring our presentation today. Daniel?
Thanks, Hiro. So welcome, everybody. We're thrilled to co-sponsor this program with CNDR. We do a few of these programs per year. And just to tell you a little bit about the Mediation Society, it's an organization of professional mediators, about 125 members, and they work in a wide variety of subject matter areas. And we have a robust set of programs that we do every year, and we get together as groups for collegiality and to get some community, as mediation is can be a solitary pursuit. So we welcome anybody to inquire about it. The other thing I would mention is we do have a new mentorship program for people to get an introduction into mediation and working with professional mediators. Thanks, Hiro.
Great, thank you, Daniel. So we've all heard the expression that because of over-lawyering and the increase in time and costs, that arbitration is now the new litigation. Others have joined that refrain, observing that mediation is now more lawyer-driven and also expensive and costly, and therefore mediation is now the new arbitration. So not willing to be undone by that, Professor Welsh is now pushing these insights to their logical conclusion with the thought that now negotiation may be the new mediation. Given the somewhat surprising evidence, at least to me, of the new ways in which lawyers seem to be including their clients in these bilateral settlement negotiations. So Professor Welsh will talk for about 25 to 30 minutes, and then we'll open it up to Q&A, followed by a reception for those of you who are with us in person. If you're joining us via Zoom, please raise your Zoom hand if you'd like to ask a question. We can't see the comments field, so don't put a chat, don't type a chat in if you have a question. Just raise your Zoom hand and we will call on you in turn. All right, so without further ado, I give you Nancy Welsh.
Thanks very much, Hiro. I really appreciate it. I really appreciate the opportunity to present here. I really appreciate all of you here in person and on Zoom. The Center for Negotiation and Dispute Resolution obviously has played and is playing a big role in the field of dispute resolution and also here in California. So as Hiro said, I have been interested in dispute resolution and in mediation for a very long time. And what I want to do before I launch into the focus of this draft paper, Lawyers-Client Inclusive Negotiation and Mediation, is give you a little bit of background regarding how I got into this. So I'm going to reach to my side here. Press a button. Let's see. I should use that instead.
Try that for
okay. On the left. Yeah. Okay, perfect. So if I go to the right, will it go back?
I don't know.
Well, Well, so I'm not gonna, this is revealing because technology is not always my friend. And I think that's probably true for all of us. Look, there it is.
Arrow key will go back.
That arrow key. Okay, great. So let me go back for just a second. So this paper is the result of work that Donna Shostowski and I have been involved in now for a few years. And I want to be really careful to note that this is not just my paper, draft paper. This really is a collaborative effort between Professor Shostowski and myself. She is highly acclaimed researcher in dispute resolution at UC Davis. I am lucky to be able to work with her on that. So a little bit of background. The flow for today, I thought I'd talk a little bit about the history of this paper as well as a little bit about the history of the institutionalization of mediation. And then I'm going to focus more on the evolution of different models of mediation and settlement negotiation. We'll conclude with implications and hypotheses, and I look forward to your comments and questions. I got to push the right number, push the right arrow here. So a little bit of history. A few years ago, Donna Shostowski got an NSF grant in order to be able to conduct really a wide-ranging empirical research regarding court-connected mediation. She was able to work with 3 courts in different parts of the United States, each of which had extensive dispute resolution programs and allowed the parties, allowed the litigants to choose which dispute resolution process they wanted to engage in. The focus of her research was both to find out what processes and what characteristics of processes litigants preferred for the resolution of their cases. So notice that is pre-process preferences. And then also to find out after their cases had reached disposition and had used a particular process for that, what their perceptions were of that process. There were many other questions that she asked as well in connection with this research, but for purposes of the conversation you and I are going to have, I think that's what's most relevant. I will add that in terms of the processes that Donna allowed the litigants to choose among pre-procedure, they included negotiation by the lawyers without the clients present, negotiation by the lawyers with the clients present, mediation, non-binding arbitration, dispositive motions, jury trial, bench trial. There may have been a couple others as well, but as you can see, litigants were able to select from a number of different processes. I'll reference back to that research in just a bit. Donna has used this really extensive data set and really mined it in order to find what she can regarding a number of different issues. But she also, as she looked at it, saw that when she looked at cases that had reached disposition through negotiation or through mediation, it would be interesting to compare parties' perceptions of those 2 processes. And she asked me whether I'd like to be involved at that point. I was very interested in working with Donna on this, and so our work proceeded. It turned out ultimately that there were not enough cases that had reached disposition through negotiation in order for us to actually be able to produce an empirical paper. That's why this paper, although it references this research that Donna engaged in, doesn't describe it in detail. But we had done significant work in terms of preparing for the research paper. And we also thought we saw some interesting tendencies, even though we didn't have anything that we could claim to be statistically significant. So that's why you see the paper that you do and why it is presenting a hypothesis rather than empirical results. I also want to mention a couple of other things regarding this. Donna and I come from 2 different professional backgrounds. Before I became an academic, I practiced law. I was a litigator. I settled cases. I ran a nonprofit organization that focused on mediation. Donna in addition to having a JD, also has a PhD, and she is an empirical researcher par excellence. I have used empirical research as the basis for thinking through various issues involving both negotiation and mediation. But I am not, I've done one qualitative research project, but I am not, I would not claim to be an empirical researcher. This makes a difference in terms of our two approaches to writing and to what we feel like we can say we know. I tend to have more of a narrative approach. I use the research in order to try and figure out, well, what does this mean? Or what could it mean? And so there are times I make leaps in terms of logic. I think Donna, being an empiricist, is much more likely to want to be sure that she can actually point to the numbers to substantiate every sentence that we've got. So that means that there has been a somewhat of a negotiation process between Donna and myself as we have written this paper. And the paper is a draft. It will continue based both on her and my continued interaction and on the kinds of responses and questions you all share today. But here's something I want to be sure to invite you to do. If, as I speak, you think to yourself, are you really sure about that? Is that something you can say you know, or is that something that you're hypothesizing, you are generalizing, you think this makes sense? It would be fair for you to ask me that question because this represents a sort of combination of those two different approaches. All right, so now let's go ahead and get started. So most of you who are listening to this are very familiar with the institutionalization of mediation, particularly in the courts. But I will just say for purposes of this slide that there was a point in the late 1980s, early 1990s, when many people were really encouraging the courts to institutionalize mediation. I was among those people, particularly in the state of Minnesota. And as we were urging the institutionalization of mediation, which we imagined as a primarily facilitative process in which the mediator was facilitating the communications and negotiations of the parties to help them come to a voluntary resolution that reflected not just the law, but also their particular interests and needs. As we were encouraging this, we were encouraging it because we thought that this approach to mediation, this process, was one that was likely to be better than litigation, likely to be better than trial for some obvious reasons. If the parties were reaching their own resolution, they were going to be exercising self-determination. That was not true if the case went to trial, right? You were accepting that an outcome was going to come from a judge or jury. We thought that as a result of parties being able to reach their own resolutions and participating in this process, they would have greater satisfaction with the outcome. It would better meet their underlying needs and interests. And I hope that as you think about the way in which I've described the mediation process proceeding, we also thought that this was a process in which they were much more likely to perceive that they had participated in a fair procedure. Arguably, that should be true with trial as well. But when you think of the litigation process and you also think of how many cases are resolved through negotiation rather than the litigation process, the only time that many litigants get a chance to speak is during a deposition. And in a deposition, I do not think anyone would suggest that that represents a procedurally fair process. Well, let's pause for a second here and make sure you and I are on the same wavelength in terms of what a procedurally fair process means, what that is. There's actually a very significant social psychological area of research that's been conducted regarding procedural fairness. This research is in the area of the workplace. It involves interactions between police and individuals. It also, a lot of it has taken place within the courts, mostly involving third-party processes in which a judge or some other individual is making a decision. There are certain procedural elements that have been found reliably to lead to perceptions of procedural fairness. Parties perceive the process is fair if They have an opportunity to speak, to be heard, to say what they have to say, especially to express what's important to them. This is generally referred to as voice. This is the most important element. They don't just want to speak, they want to know that somebody has actually listened to them. And so a second important element is trustworthy consideration. That word trustworthy, it means that it's not necessarily, they don't necessarily have to believe that the person totally understood what they had to say. What they have to believe is that that other person was really trying to understand what they said. Third significant element, that they are treated in an even-handed way and that the forum is one that is not biased against them, also described here as a neutral forum. Fourth significant element, that is they're treated in a respectful or dignified way. If a process includes those elements, it is very likely, but not guaranteed, but very likely that it will be perceived as procedurally fair. And you might say to yourself, well, that's nice, but who cares? That would be a reasonable question. Well, here's one of the reasons to care. If people perceive a process as fair, they are more likely to perceive the outcome as fair, even if it is not what they wanted. Why does that matter? Think about our courts. Isn't it important that people comply with the outcomes that our courts produce? Absolutely. So it's important that compliance is heightened. In addition, the institution that provides the process is more likely to be perceived itself as legitimate. Is procedural fairness always going to result if a process includes these elements? No, not always. There are certain exceptions. For example, people who are of high status or are repeat players within a particular setting, it is less likely that their assessment of distributive or substantive fairness will be affected by whether or not they were treated in a procedurally fair way. They tend to look at the bottom line. There are some other important exceptions as well. One other issue that I want to be sure to mention is that it is possible to manipulate processes. So they sure look like ones in which somebody had an opportunity to be heard, received consideration, they were treated in a dignified way, etc. But you know what? It's all a sham. It can happen. So are these important limitations on the procedural fairness literature? Yes, they are. Is procedural fairness still an important concept? Yes, it is. All right. So with that little side note, focusing on procedural fairness or procedural justice, let's take a look at what seemed to happen as mediation was institutionalized in the courts and I think also used more frequently on a private basis. First, one of the things that was noticed, discovered, it might have been happening from the very beginning, but not noticed, was that relatively frequently, mediators were using more evaluative interventions. What do I mean by that? That mediators were assessing the strengths and weaknesses of parties' cases, they were suggesting settlement options, they were even potentially identifying what they thought would be likely if the case went to court. All of these represent evaluative interventions, going from gentle evaluative interventions to pretty significant evaluative interventions. That, especially in court-connected mediation and other mediations in which lawyers were accompanying their clients, the lawyers tended to dominate the communication that took place. Parties weren't talking so much, it was the lawyers who were talking. And one of the other things that was noticed was that joint session, its use was being sort of marginalized. Rather than staying in joint session and keeping everyone together, instead it looked like caucus was being used more and more frequently. And in some instances, people indicated that mediations were proceeding entirely in caucus. Now, I want to be careful with what I'm saying here. Am I saying that all mediation, all court-connected and private mediation was moving in this direction? No, I am not saying that. There still was mediation going on. including mediation, that was facilitated by mediation clinics in many law schools, including this one, that I am certain involved lots of facilitative interventions by the mediators and significant, if appropriate, use of joint session. But this model seemed to be happening more and more. If you think about this and you think about what difference it could make, what I would ask you to ask with me is, so what's the effect of this changing this model on party self-determination? What's the effect of this model on their perceptions that they were treated in a procedurally fair way? What's the effect of this model on their satisfaction with the outcomes achieved? And maybe even whether those outcomes include something creative that reflects their underlying interests. Around the same time that folks were noticing this evolution in terms of mediation, people started asking, are we comparing mediation to the right process? Is it really litigation or trial we should be comparing mediation to, or is it actually lawyers' bilateral settlement negotiations, the process that is used overwhelmingly in order to resolve litigated matters? Interestingly, people wrote, including me, people wrote about how mediation, depending on how it's conducted, and it could include evaluative interventions, it could include caucus, it could include all these things, still, it had the potential, in fact, was likely to provide more self-determination, more procedural fairness, more outcome satisfaction than lawyers negotiating settlements. I want you to think with me for a second. Well, we'll go here first. Well, I want you to think with me for a second. When I say lawyers negotiating settlements, who's involved in that process? It's just the lawyers, right? What we're comparing makes a difference. We get to the evolution of negotiation in just a second, but I think for right now, it's also worth letting you know some of the results of some empirical research that has been conducted regarding mediation, especially these questions having to do with joint session, caucus, and parties' participation. So first, in terms of joint session versus caucus, there have been claims and there has been research supporting the idea that in certain parts of the country, California included, a lot of mediation is devoid of joint session, certainly does not begin with joint session. Although there have been regional differences that have been identified, there is still a question about exactly what's going on in terms of joint session and caucus. There's been some research that's been conducted recently by Roselle Whistler and Art Hinshaw, indicating that there still very frequently is an initial joint session. However, they've also indicated that joint session is a shadow of what it once was. And is being used now really just in order to allow the mediator to introduce the mediation process, maybe introduce the parties to each other, not necessarily to begin any sort of communication between the parties. But still, their very recent research indicates that joint session is not dead. It still is being used at the beginning of many mediation sessions. What about the effects of caucus? There are a number of areas of research that have been done in connection with this. I think that what we can say at this point is that there's some suggestion that caucus can help make it more likely that settlement will be produced in certain settings. But the only setting where that's really been substantiated is labor. There isn't study of this in connection with commercial mediation. Meanwhile, in other substantive areas where mediation is used, it's been found that mediation very frequently reduces very frequently results in dissatisfaction is not quite the word that I want, lower satisfaction, lower perceptions of fairness with the mediation process. It has a negative effect on party perceptions of the process. In certain settings, as in the family area, although caucus is likely to lead to more trust in the mediator, it is also more likely to lead to parents, divorcing parents with children, to have less faith in their ability to work with each other, which seems like a negative effect down the line in terms of the use of caucus. What about the interaction of joint session and caucus with parties' participation in mediation? This is very interesting. The research that Roselle Whistler and Art Hinshaw conducted indicates that although parties are more likely to be part of opening statements if they're in joint session, they actually are more likely to respond to mediators' questions and are more likely to ask questions of the other side if they're in caucus. So this indicates that parties' participation can be quite significant in caucus, and in fact can even be assisted by the use of caucus. But let's talk a little bit for just a second about participation as compared to voice. Do you remember voice? I talked about that in connection with procedural fairness. So Roselle Whistler also conducted research a while ago where she found there was really a distinction between participation and voice. She found that if parties perceived that they had voice, they were much more likely to perceive the mediation process as fair. Good. If they participated in mediation, and notice how that's going to mean sort of engaging in the give and take of negotiation that occurs within mediation, there still was a relationship between that and perceptions of procedural fairness, but not as strong a relationship. And the parties who perceived that they had participated more also indicated they felt more pressure to settle, which suggests to me a difference between the kind of voice that is involved when you have a chance to say, here's what happened to me, here's why I care, here's what I want. That voice is different than the voice of negotiation. I think that has the potential to be relevant to us in the mediation field. And then also in connection with this research, but other research that preceded it, Roselle found that if clients' lawyers participated on their behalf, if they spoke on behalf of their clients, the clients did perceive that they had voice. It didn't have to be only from them. Now, does it matter whether the lawyers understood their clients and had a good relationship with their clients? Of course it did. I don't think, however, that she was able to get data regarding that. What about that element of trustworthy consideration? I have written, others have written about the importance of a mediator providing trustworthy consideration. And there is definitely research indicating that the consideration by an authority figure who's a decision maker, that makes a difference. Is the mediator a decision maker? No. But is the mediator an authority figure and kind of a representative of the court, at least in court-connected mediation? Of course. And so do people care that they've received trustworthy consideration from the mediator? Sure. But do they also care whether they have received consideration from the other party? There's research that's been conducted in connection with transformative mediation, which is a process that has no caucusing, it's only joint session. That found that people cared more about whether they had received trustworthy consideration from the other party than from the mediator. So does this have the potential to make a difference? Sure. And there's also a small qualitative research project I was involved in, which suggested that parents in special education mediation definitely cared whether they had received trustworthy consideration from the school official. Do you notice the power differential there? One more piece, outcomes. How different are the outcomes in mediation as compared to litigation and negotiation? Sometimes, not usually. That's what's suggested by the empirical research that exists. So if you think about all of the assumptions that went into why mediation would be so great, Notice how the research is forcing us to refine our thinking based on what mediation looks like. Okay, so now let's move to lawyers' bilateral settlement negotiations. Has there been evolution there? Certainly. Yes, there has been. Traditional picture of lawyers' settlement negotiations is just the lawyers by themselves, no client in attendance. But now I want you to think about some other things we've heard about recently. Collaborative lawyering. How does negotiation work in collaborative lawyering? They use four-way meetings with the lawyers in attendance and also with their clients in attendance. Cooperative lawyering, kind of a lesser version of collaborative lawyering. Integrative lawyering. Holistic lawyering. These both involve focusing on clients' interests, not just focusing on the law. As I describe these, doesn't it sound like these approaches to lawyering are borrowing from some of the enthusiasm for mediation that existed when mediation's institutionalization was being encouraged? People are nodding in the room. I'm hoping some people are nodding off there in online land as well. Okay, what do we know about lawyers' bilateral settlement negotiations? Well, first of all, I have to say, in a lot of ways, we know a lot less about lawyers' bilateral settlement negotiations than we know about mediation. I complain that we don't know enough about mediation, but there's a dearth of information when it comes to lawyers' settlement negotiations, which is crazy given how frequently cases are resolved through negotiation as compared to other processes. Nonetheless, I will share with you what I think I can say we know. First of all, I mentioned that Donna Shostowski's research had asked for parties' perceptions before they engaged in the procedures in the courts. And they were asked which procedures among all those that I listed did they prefer. The top three scoring within, they clustered together at the top. Mediation, that's good. Bench trial, the conversation about why they didn't want a jury trial is when we were not happy with that. But you know what the third one was? Lawyers' negotiations with their clients present. You know what did not show up there? Lawyers' negotiations without their clients. So does it seem as though that suggests people do want to be able to see what's going on, at least, as their case is being negotiated to resolution? Yeah. And there also is some limited data. So John Barkai and Elizabeth Kent reviewed data from the Hawaii courts regarding how cases have reached disposition. And they found that in 1996, 17% of the cases that reached disposition through negotiation were cases in which the clients attended the negotiation with their lawyers. That percentage increased to 24% in 2007. John Landy wrote an article in which he profiled 14 different negotiations. This is not random sampling, but 5 of those 14 negotiations were ones in which the clients attended along with the lawyers. And then as Donna and I took a look at the data that she had regarding cases that had reached disposition through negotiation, we found that 50% of those cases were cases in which the clients attended the negotiation. Now, I need to say, this is really important. Half of those 50% were cases in which the clients accompanied their lawyer. The other half of those 50% were cases in which the lawyer and the client were the same person. That's really accompanying the lawyer. So now, given this limited amount of information I have shared with you regarding empirical data on negotiation, but interesting information, isn't it, about how increasingly clients are attending lawyers' settlement negotiations? Now, if we compare the model of mediation that is lawyer-dominated, more evaluative, probably caucus-dominated, with lawyer settlement negotiations that include their clients, Which of those is more likely to provide the parties with increased self-determination, greater satisfaction with the outcome, greater opportunity for voice? What Donna and I are suggesting is that negotiation model could very well come out on top. That's the implication of this. Do we need more data and research to support this hypothesis? Oh, yes, absolutely. Are we suggesting a real faith in lawyers and lawyers' willingness to allow their clients to play a significant role in negotiations? Oh, yes, we are. Do we know that that faith is entirely justified? Oh, no, we don't. So do we know for sure that the lawyer matters in this? Absolutely, for good and for ill. Talking a little bit earlier today about how important it is for lawyers to be preparing their clients to participate in mediation. But think about how that's even more true if the client is coming to a negotiation with them. And one of the hypotheses is that the lawyer might actually do more to prepare the client for negotiation than for mediation, because now there is no mediator to help referee. What else? So right now, a lot of courts order parties into mediation. Should courts perhaps be allowing parties to satisfy that requirement if they elect to go into client-inclusive settlement negotiations? We're suggesting that, yeah, this could very well meet all the same goals that mediation did. And then lastly, in connection with this, if it turns out that the picture of lawyer settlement negotiations is changing in this way, and if we think that is a good thing, should we be doing more in order to really prepare law students to play this role? In making presentations on this paper previously, I have been sure to notice that many clinics believe in client-centered lawyering, and client-centered lawyering is very likely to, number one, ensure that the lawyer really understands the client's goals, but also makes it more likely, I think, that the client may be included in negotiation, or at least is treated as a partner, even if they're not at the negotiation table. Think about how that's going to be even more the case if the client actually is at the negotiation table, has a chance for voice, or a chance actually to hear their lawyer speaking on their behalf, gets to see whether the other side is really listening to what they have to say, participating in the development of a settlement option, etc. So that brings me to the close of my presentation and our hypothesis. I look forward to your questions and thoughts.
Thank you so much, Nancy. Any questions from the in-person audience?
Got someone right over here.
Hi, my name is Ashley. I'm a 2L here at UC Law SF. So one of the questions I had, and my apologies if it's duplicative, but this idea of voice versus participation, could you add some more color to that for me? Because in reading your paper, I kind of thought of them as like one and the same in terms of, you're speaking on behalf, you're advocating on behalf of yourself. And so I know Wessler had drawn some distinction between the two. So any type of color on that would be
absolutely. So I'm going to respond to your question, and then you let me know if you'd like something more.
Okay.
So the kind of voice that has previously really been the subject of empirical research has been where somebody has the opportunity to speak to the court, for example, and to say, to express their argument, tell the court what has happened, express their arguments, talk about what they think the right resolution would be. And you notice how you do that kind of thing at the beginning of a procedure like mediation. That's when you get a chance to be heard. This is what you've been wishing you could say for such a long time to somebody, whether it's the mediator or the other party. Okay, so great. Everyone gets a chance to say that. Now let's imagine you go into caucus, and in caucus, now we're going to start bargaining. And now when you speak, it's going to be speaking in response to the offer being made by the other side, or speaking about why what they are saying is not true, and now you're in negotiation speak, which feels different than just getting a chance to be heard by somebody. So what I'm suggesting, and what I think that Roselle Whistler's research suggests, but if you ask me right now, do you know this, Professor Welsh, or are you at this point sort of hypothesizing? I would have to admit to hypothesizing. But I think what this suggests is that first piece, getting to be heard about who you are, what you care about, why you're there, that's the voice part. If you know you were understood, that's great. Now, when you have to go through the give and take, the bargaining and negotiation, how many of you really like that process? I've got a few. Does it feel to you like you're being heard at that point? Or now you're kind of playing the game and you're figuring out where you can go? That's different. So that's the distinction I'm drawing based on the data that exists, but I can't say for sure. I know that distinction is there.
Let's see. So two unrelated questions that sort of popped into my mind, one on remedies and one on culture. So the remedies one, I think is more straightforward. So you listed a variety of the advantages to mediation that have been listed. One of them that's been posited is remedial creativity.
Yeah.
And so in some of the research, like unemployment mediation, there this is by Craig McEwen, I think, looked at this and found that in a significant number of cases, there's a sort of creative, if we think of this as creative, something other than what a court could order, remedy, which was an apology in some significant number of cases. So I'm just curious, I don't actually have a view on this. To the extent that creative is narrowly defined as just remedies that a court couldn't order, I'm not sure, I don't have really an opinion, but I'm curious if you do, on whether lawyer-to-lawyer mediations are more or less likely to lead to this, assuming that that's a good thing. And then to the extent, and then I just wonder, is there some extent that some mediators, and maybe it's a trivial number, I'm not sure, actually do add in creative solutions that either lawyers wouldn't think of, or, and this is a trickier question, that lawyers might be, by the terms of their compensation, incentivized against. So lawyers who are getting a contingency fee will be incentivized to get money in an employment case, even if the party might be more interested in a change in their workplace or in an apology. So that's question one. Why don't I just throw that there, and then if there's time, I'll ask you more of a comment about culture and whether that might apply.
So in terms of, I generally would equate creativity with remedies that a court normally would not be able to order. And an apology certainly is something that a court can't order. Right. So, but there's other research that's been conducted. So Elizabeth Gordon's research is what's coming to my mind right now, which indicates that the outcomes in mediation are not significantly different than the outcomes that that a court could order that would be the result of litigation. And, you know, one suggestion about why that would be is that frequently it's the lawyers who are negotiating and they choose a lawyer as the mediator. And it's likely that their sense of the resolutions that could be reached are somewhat limited by that. You know, I don't know of any research that compares mediation, let's say a community mediation, where you just have the parties there and not necessarily a lawyer mediator. I don't know of any research that exists that has compared the level of creativity that seems to exist in that setting as compared to a court-connected, lawyer-represented mediation.
Yeah, nice.
Yeah.
So, so let's follow.
Yeah.
not a follow-up, completely unrelated question.
But can I finish, because I want to finish in response to the earlier part. Right? So, and do I think that lawyers may be incentivized against mediation resolutions that include non-tangible elements as opposed to money, especially where we're talking about contingency fee payments? Oh, yes, I definitely think that lawyers could be incentivized to try and help their parties come to an entirely monetary settlement. And I will also say two other things in connection with this. One, compliance with the monetary settlement is a lot easier than compliance with a settlement that includes both money and some kind of a continuing obligation, right?
No, not necessarily. So that's a category that's a category, correct? So if there were a category that in a disability case was you'll provide a certain kind of accommodation,
Okay.
yes, that's a continuing one. But there's another category where it's kind of one-off, like we will provide this letter of reference.
Yeah.
We will delete these files.
Yeah.
We will build a wheelchair ramp.
Right.
We will issue this letter of apology to you.
Right.
Yeah.
So if it's a one-off and it can just be accomplished, compliance is probably would be significantly better. But the other thing that I want to mention is that I have colleagues within the dispute resolution world who have said to me, creativity doesn't really matter. What matters is that somebody is getting a good result for them, and sometimes the lawyers are correct in that the best result is the largest financial award that they can get. So I want to be careful, I want to be careful in evaluating what is the right kind of resolution and what is the wrong kind of resolution. It all really depends on the case. I just think that in terms of the reasons people had for advocating the institutionalization of mediation, creativity, and customized tailoring. Now, please go ahead and ask your second question.
That was, in all my years of teaching since 1995, I can't think of a better response to a question that I asked. That was like so thorough. And I learned so much as you were saying that. By the way, I would just say, I would add, if you had time, whatever, add part of that into a footnote or to a section of the paper. And that last part that you said, it might vary by case category. I would give as illustrations that there might be plausible reasons why you would think in certain categories that it would make a difference, the creativity non-legal. So for example, in continuing relationships, so stereotypically in families, if you think it's good for there to be continuing relationships, which is controversial given like say Martha Feynman's work, but still that might be one. Another area would be like estate litigation, which is another area. The question about the culture one, this is something I learned from my students. So we have a very diverse group of students here. And over the last several years when we've been covering mediation, many students have volunteered and others jumped on with this, that they would never use mediation for their own disputes involving their friends or their family. Because I asked them in an open-ended way, hey, when would you use these various styles of mediation or arbitration? How would you do it? And many say that in their culture, and this is the students have been both African and from various Hispanic, Latino cultures. And so in our culture, that would be totally unacceptable to air our dirty laundry that way. Going to a priest might be okay, but going to something called mediation wouldn't be okay. So as I read your paper, thinking of what they were advocating, I thought, wow, an interesting add-on to your argument about the new mediation being bilateral negotiation. Maybe it's actually in some ways, what's this called? Culturally sensitive or culturally even appropriate, because some people might find it easier to go with their lawyer to a sit down than they would be to go to something that's a mediation. Totally speculative. I don't know about that.
I have no idea. Let me ask you a follow-up question. So the idea that potentially going to a priest, that would be okay. would that be where the priest, where the couple or relatives are both with the priest, or would it be one-on-one? So would it be joint session or caucus?
Yeah, I'm not sure about that one. And I would say that, another area I would like spin into this is a teeny tiny itsy bitsy percentage of American Jews are Orthodox, maybe 15% or so. And in that teeny tiny itsy bitsy percentage, there's a custom or to some extent religious dictate, it's described in different ways, to go to rabbis to resolve not just family disputes, but business disputes as well. And so I know the answer to that one, which is that in some of those, based on an obscure case where this was treated as arbitration in Michigan, the rabbi met with the parties separately, and that was deemed by the court to be procedurally unfair, such that they wouldn't enforce the so-called arbitration.
So interesting. No, so I think this is a really wonderful point, and there's a paper that Chris Hyman and a couple of others wrote a long time ago that suggests that it addresses the question: why aren't mediators being engaged more frequently in big public policy disputes? And one of the consensus from it is, well, people tend to go to third parties who have authority within their world and are connected. These are the wise elders, right, that are within their community. And I have thought about how that actually applies within the court-connected context as well, in that if you think of the lawyers as being the ones who are selecting the mediators, who do they tend to select? They tend to select the mediators who have authority and connectivity within the legal world. So, this idea that it's cultural, like who you choose as the mediator and who you're comfortable talking with and who shares norms that are important to you, that it's cultural, in a whole wide variety of ways.
Other questions from the Zoom audience or in person?
Can I ask a question of folks? Are you surprised to learn that there is this significant percentage of lawyers who are bringing their clients to negotiation?
Well, actually, I had a question about that.
Right,
So
fine.
how significant really is that, I guess, is my question. For example, the Barkai study, so that was interesting that there was an increase from 1996 in percentage terms.
Yes.
But in absolute numbers, how many cases are there? The 50% that you noted in Donna Shostowski's study, at least half of those were when the lawyer and the client were the same. So I would say it's more like 25%.
Yeah.
But what's the underlying numbers? Because I think part of the persuasiveness of the argument is that, hey, there's this new normal, right? And this could become the new mediation. But do you have a sense of what those numbers are? Because I think that makes a difference.
So let me just say first, I don't think that we can say that this is the new normal. I think,
or it's coming down the pipe.
I think that's fair. And probably the sort of amusing response to your question in part is, I thought that the percentage of lawyers who had clients come to their negotiations was zero. So this was a huge surprise to me that it was anything. But then, in terms of the actual numbers, so John Barkai and Elizabeth Kent's article, I think it includes numbers as well as percentages. And you had asked me earlier about the numbers in Donna's research, and I cannot remember them off the top of my head. I know that they weren't huge numbers, and that's why we weren't able to come up with anything, or at least that's a significant part of why we weren't able to come up with anything that was statistically significant. But this is a very important suggestion for an addition and revision to the paper, for sure, including some of those apps. But let me go back to my question, which was, that it's not 0%, but instead that we actually do have a noticeable percentage of lawyers who are bringing their clients to negotiation. And I think in a way, I would really like to hear from those on Zoom whether this is a surprise to any of you.
have Tim Alger who has his hand up.
Hi, I'm a civil litigator. I do business litigation, and I bring my clients to every mediation.
What about negotiation?
Well, negotiation a lot of times is by email now. A lot of the, if you're doing one-on-one negotiation with opposing counsel, it's emails, and your client is not included in that.
Okay.
But a mediation, I always have my client there. But I had two comments to make that I thought might be helpful. Is that this issue of creative solutions in the civil context, at least in business, the creative solutions, as much as I want to get there, they never get there because you end up in a situation where you're a zealous advocate for your client and you want to get out of there without the likelihood of further dispute between the parties. You want to wrap it up. And so you want to wrap it up with something that's like a judgment. And you want to terminate the relationship unless they absolutely have to keep doing business together. They want to be finished and they want to have a payment plan or whatever it is, but it needs to be an enforceable settlement agreement. And so when you want that, if the client wants that and you want that for the client, then creative solutions never work. You end up no collaboration will get you there. What you want is people want to end the pain of legal fees and end the pain of dealing with the antagonist.
Yeah.
They want to wrap it up. And then the other final comment I wanted to make, which came to mind, is that the last one I had, which was all day, most of mine are all day, 12 hours plus, is that there's some factor that I don't think anybody talks about it, that is, if you're a civil litigator and you've got your client there in mediation, you're on the spot because you talked your client into coming. You were involved in selecting the mediator. You felt that the cost of the litigation was such that it was smart for your client to get into mediation, that there was a window of resolution. And so it's almost like your reputation and the quality of your representation is at stake. And when I was at this last one just recently, which was, we had a retired federal judge there, I felt on the spot because I was afraid the thing was going to fall apart, and it was negative towards my advice and my getting the client there in front of that particular retired judge. So
in a sense, you feel responsible. You are responsible for the selection of the mediator, and in some ways, you end up feeling sort of responsible for how the mediator is conducting the mediation.
Yeah, if the mediator doesn't come back with us, if the mediator is falling short, which in fact we had in this situation, again, it was a long-time retired federal judge from Los Angeles. With the mediators falling short, or the client perceives the mediator to be falling short, it reflects, you find that maybe I shouldn't take things so personally, but you find it reflects on you because you were an advocate for selecting, or at least you bought into the selection of this particular mediator, and you want it to succeed. You don't want it to blow up because of the bad choice of dragging your client there and spending the money getting ready and doing the briefing and spending all day there, and then the whole thing blows up and you don't get it resolved.
So I think we have time for maybe one last comment or question. If anyone wants to have the last word. Alexis.
Your question about like how.
Can you speak up a little bit because they can't hear.
So the question about how are we surprised that the people are bringing their clients with them? I think there's a shift in the mindset of the client-centered lawyering as a result of that.
Do I think it's a shift in the mindset of the clients as opposed to the mindset of the lawyers?
Well, the idea of the client-centered lawyering, like I did the clinic, I've done great clinics, and there was always a section on how important it was. Do you think that's like new? And my understanding is it's a newer concept too, having the client-centered lawyering compared to what they taught, around back in the day. But
So client-centered lawyering is a really important concept, and I don't remember the exact year that it came into being, but I think it even preceded mediation. So it's been around for a while as an approach to lawyering. Is it consistent with this things like integrative lawyering and holistic lawyering? Yeah, I think it absolutely is consistent. Does collaborative lawyering take it one more step? Yeah, I think it does, because collaborative lawyering actually specifically provides for having your client with you at the table when you're negotiating. And the other piece of collaborative lawyering, the controversial piece of collaborative lawyering, is that clients, when they sign the retainer agreement with their lawyer, they agree that they are going to reach resolution of their case through a consensual process. And if they decide to abandon the consensual approach and instead go back into adjudication, the lawyer withdraws from representation. And now that client is going to have to get a new lawyer, educating that lawyer about their case, with that lawyer then responsible for the traditional litigation process and then potentially negotiation that will occur. Can you see how, the idea of collaborative lawyering ratchets it up, right? Now the lawyer is playing a huge role in ensuring that a consensual process, specifically negotiation accomplished through these four-way meetings, is being used to resolve the case.
Okay, great. So thank you again, Nancy Welsh, for sharing your thought-provoking work. Thanks to the Mediation Society for co-sponsoring this talk, and thank you for joining us via Zoom and in person and sharing this event with us.
Thank you very much. Really appreciate it.